Well, good afternoon, and welcome to our event, Net Neutrality, Revisiting the Repeal. I'm Mark Jamison, non-resident senior fellow with the American Enterprise Institute. On October 19th, the Federal Communications Commission will vote yet again on whether to regulate the internet under laws largely crafted 90 years ago to regulate telephone utilities. This raises issues about the FCC's authority, the cogency of the pending decision, and many other legal, economic, technological, and institutional concerns. Here to share his thoughts on this matter is FCC Commissioner Brendan Carr, the senior Republican on the commission, where he served previously as general counsel. Nominated by both President Trump and President Biden, Carr has been confirmed unanimously by the Senate 3 times. Described by Axios as the FCC's 5G crusader, Carr's led the FCC's work to modernize its infrastructure rules and accelerate the build-out of high-speed networks. His work cut billions of dollars in red tape, enabled the private sector to construct high-speed networks across the country, and extended America's 5G global leadership. Commissioner Carr will speak for 5 to 10 minutes, then we'll take 2 to 3 questions from the audience, and then we'll follow with a panel discussion until about 2:15. To our audience, please email your questions to Kate Beinkampen, that's KATE.BEINKAMPEN @AEI.org, or tweet to hashtag AskAEITech, that's hashtag AskAEITECH. Commissioner Carr, the floor is yours.
Mark, thank you so much. Great to be with AEI at this event. And I, for one, I'm really looking forward to the important part of this, which is the panel, to see what all of these experts have to say. You know, at the outset, I gotta offer that one of my favorite movies was Back to the Future, and category. I think this is Back to the Past, as the FCC is once again having this sort of sclerotic, backward-looking debate over the best path for the internet. Frankly, a debate that I think was rightly settled long ago, and was particularly settled, as I'll get into, during COVID-19. But at the outset, I think it's important for people to understand 2 very distinct points that in classic Washington sense are always conflated, which is net neutrality rules on the one hand, Title II regulation of the internet on the other. The people that are proponents of sort of heavy-handed Title love to talk about net neutrality. What they don't love to talk about is Title II utility-style regulation of the internet, which is at its core what this entire endeavor is about, which is getting 1930s era Section 201 and 202 of the Communications Act, which really empowers the FCC to decide what conduct is just and reasonable on the internet, not according to an objectively reasonable standard, but based on what the FCC itself determines is just and reasonable. And so it's funny, people put these polls out saying 80% of people love net neutrality. I'm like, I'd like to make the 20% that don't like net neutrality. Net neutrality is very simple. Actually, it's no blocking, no throttling, no sort of anti-competitive prioritization schemes. And on that, there is a tremendous amount of common ground. And there are a variety of ways that we can keep, because I think we have it, net neutrality. Or if you don't believe that we can actually, enshrine or codify net neutrality in ways that have nothing to do with Title II. And the reason why this debate has gone on for so long in DC, one, I think it's pretty profitable for activist groups, but 2, it's because people fundamentally aren't interested in solving net neutrality. They are fundamentally interested in expanding government control of the internet, and that's what the very separate and distinct Title II does. But before I go back there, I think maybe it's helpful to back up 6 years and remind people that we all lived through probably one of the greatest hoaxes in regulatory history in this country. And when Ajit Pai, Mike O'Reilly, myself voted to end the 2-year experiment with Title II and go back to the 20+ year regulatory framework of light touch, not no regulation, light touch for the internet, there were all sorts of predictions that were made. CNN ran the World War III style banner headline, "End of the internet as we know it." The Senate Democrat caucus tweeted that with time, We were told that free speech and the right to organize would no longer exist. And obviously, all of those apocalyptic predictions did not bear fruit. In fact, what did happen? Internet speeds on the mobile side are up 6-fold. We didn't go backwards. We didn't go back to one word at a time. We didn't stay static. The exact opposite happened, the prediction. The internet sped up in this country. Millions of Americans were pulled across the digital divide, including because of our regulatory structure incentivized totally new technologies to hit the market that didn't even exist when the FCC went down the Title II path. Fixed wireless, for instance, right now is taking massive market share, or we're taking at least market share. I don't know if massive is the right word. They're taking market share, a technology that had basically no market share, effectively speaking, when this Title II debate started. We have this new generation of low Earth orbit satellites. We got more fiber going in, cable going in. It's really an interesting time for competition across modes of technology. And again, millions of people brought across the digital divide. More Americans than ever have a choice for competition for two or more high-speed internet providers. We got a great example right where Rosalind Layton is right now in Europe is a great counterpoint to America. Long regulated the internet in a utility fashion, very similar to what would happen under a Title II approach. And the results are very telling. As around the globe, when COVID-19 hit, internet traffic levels in this country spiked through the roof, increased 20 to 30%. To put that in perspective, that's about the same traffic increase that a network operator would expect to see over the course of an entire year. So you took basically the year's worth of traffic growth and put it on the internet overnight. And what happened in Europe? Well, network speeds there were slowing down. The chief regulator, Thierry Breton in Europe, Netflix, and asked them to down-res, to throttle, to ration, in my view, their streaming service, because he was rightly afraid that the networks would break. In America, we made no such call to any streamer. Our internet speeds at the time were 83% faster than what they were seeing in Europe because we had this way of having a legal framework that both protected consumers, but also incentivized massive investment in the network, 2 to 3 times more per household, per person investment in the US than in Europe. So I think that's the greatest sort of test case or stress test of global telecom policy. Europe, in its heavy-handed approach, did not prevail. America's did. And I guess fundamentally, we have to ask, what Title II itself plainly involves a problem. Title II results in investment scattering. We saw that. The evidence at this, and it's creating a regulatory headwind that's going to make it that much harder for small and rural providers to build. I mean, they're facing a lot right now. 20 to 30% increase in costs from inflation and supply chain difficulties. And then we're going to layer, sort of Title II compliance costs on top of that. So that's going to make it harder for the Biden administration to deliver on its goal of making sure that BEAD is a success. And at the end of the day, the proponents of Title II aren't even going to get the sort of claimed benefit that they want of net neutrality. And that's because if you actually look at the DC Circuit decision upholding the last round of Title II regulations, the DC Circuit expressly said that as long as an ISP were to disclose it, it could engage in what it says, I'm reading here, editorial intervention, such as throttling of certain applications chosen by the ISP or filtering of content into fast and slow lanes based on the ISP's commercial interests. And so it can engage in very non-neutral conduct with Title II. So Title II is not the solution to codifying net neutrality rules that its proponents think. And again, you don't necessarily take my word for it, this won't work. Just look no further than President Obama's top lawyers at the Department of Justice, Solicitor General Verrilli and Gershengorn. They put out a filing a couple weeks ago that said Title II, not neutrality, Title II regulation of the internet would be a massive, massive expansion, transformative in their words, expansion of FCC authority into something that is vital to the personal lives of millions of Americans, the internet. And in their words, it will not survive an encounter with the Supreme Court's major questions doctrine. And lawyers are very famous for hedging things and putting, it could be argued both ways. These are very sharp lawyers, and they said it will not survive. And as a result, they said it's folly and it's a waste of the FCC's time. And to that extent, I fully agree with President Obama's lawyers. There's a lot we need to do at the FCC. We need to get back on a leaning in on spectrum. We need to continue to reform infrastructure rules, so BEAD and a success. There's a tremendous amount on our plate, USF reform, and so much of that is going to get pushed to the back burner, in many cases knocked off the burner entirely. We return to this backwards looking debate over Title II. And fundamentally, and I'll end with this, as a regulator, I think we should hold ourselves up to the Gretzky test, right? We should be looking to see where is the puck going, where can we be helpful to emerging trends. And instead, the agency right now is failing the Gretzky test, and we're just, relitigating debates that are frankly about 20 years old at this point. So I think it's a mistake. So put me down as a maybe for the vote next week. I think that might be fair. And with that, Mark, I'm happy to take a question from you or anyone else, or if you feel like we're ready to jump in, and happy to do that as well.
All right, very good. Well, thank you so much, Commissioner. And audience, if you have questions, please do email them to Kate or put them on Twitter, now called X, at the hashtag AEI, Ask AEI Tech. So I do have one question for you, Commissioner. And that is some of the reasoning that the chair put forward for why we need this Title II authority now, or why you need the Title II authority, had a lot to do with national security and network security. That seemed a little bit new to me. What are your thoughts on that? Is that something that we're just really vulnerable unless the FCC has Title II authority?
Well, I welcome the idea that the FCC has abandoned some of the really sort of apocalyptic Chicken Little reasons for why we need this, but these new explanations for why we need Title II actually don't fare any better than those old ones. So, for instance, national security, which I know has been trotted out early on in this debate. Here's the fact: the item itself, if you read it, it doesn't identify a gap in national security that Title II regulation would fill. In fact, the FCC isn't even the lead agency when it comes to security issues in the communications. S is empowered, Treasury actually is empowered, DOJ is empowered. They're the leads. And so the administration has all the authorities that it needs already to deal with bad actors in our communications sector. It's just a question of whether they use it. So that's not a reason at all to do Title II. In fact, one of the things that the item gets into some detail on is this, what we call BGP, Border Gateway Protocol technology. And there's this sort of suggestion that we need Title II for that. But BGP wouldn't even be classified as a Title II service under the FCC's decision. So again, there's no gap in authority here that Title II itself would solve. Similar with public safety, we have outage reports already for technologies that are not classified and regulated under Title II. So I will agree that there's some new arguments being offered, but they don't fare any better than the old ones.
And the vote on the 19th, that is to launch a rulemaking. That isn't to adopt actual rules. Is that correct?
Yeah, no, that's right. So next Thursday, we will vote on the proposal to seek comment. My guess is then we'll move to a final order in a bit of a truncated way, but still sometime in the late spring is my guess. But I think, the order will look basically the same as the NPRM if I had to guess. And if anything, look, where we started the last time around, the notice of proposed rulemaking was far less radical than this one. That one at least sought comment on doing things other than through Title II. In fact, did not propose Title II as a lead idea. So this one is, further to the left than where we were in whether it was 2014 or 2015 with the last version of the Title II notice. So I don't think it's going to get substantially better than, frankly, I think it's a pretty radical proposal to start with.
All right, and one more question before we go to our panelists. If the FCC, after the notice and receiving comments, decides to put broadband internet under Title II, then the Federal Trade Commission actually loses some jurisdiction that you would then take on. Would you touch on that? Because that was awkward back in 2015.
This is really interesting. So a lot of people say, well, we need Title II. It's pro-consumer. There's a provision in the law that says broadband is either regulated by the FTC or the FCC. You can't have both. And so right now, broadband and their privacy practices, for instance, are regulated by the FTC, which is still the nation's premier Consumer Protection Agency. Some people may or may not like the current chair, but it is still the premier lead consumer protection agency. So if we reclassify broadband under Title II, we strip the FTC of 100% of its authority over broadband, including privacy. And unlike 2015, 2016, we can't impose new privacy rules on ISPs because of a law that was passed in 2017 that prevents the FCC putting same or similar rules back in place. We were creating a privacy donut hole from a rule perspective that simply can't be filled. And I think that's another sort of APA problem with this whole approach, let alone a protection problem too.
All right, Commissioner, well, thank you for your insights. I understand you're sticking around to help us with some of the panel discussions, so thank you for giving us all the time that you can today.
Thanks.
Let me now turn to our panel of experts, and I'm going to introduce them and then ask each to offer some comments, either response to the commissioner or their own thoughts. We have with us Jeff Eisenach. Jeff is a non-resident senior fellow with AEI and a managing director with NERA Economic Consulting. Rosalind Layton, she's a visiting researcher with the Center for Communications, Media, and Information Technology at the Aalborg University in Copenhagen. And Daniel Lyons, also a non-resident senior fellow with AEI and a professor of law at Boston College. So I'd like to ask each of you to offer your thoughts on either what the commissioner said or just your own thoughts on what's happening now or what could happen at the FCC. And about for the audience, about 2 o'clock, we will then start accepting questions from the audience. So please email them to Kate or put them on the Twitter or X. So Daniel, let's begin with you. Then I'll go to Rosalind and then to Jeff. So Daniel, take it away, please.
Thanks. So I appreciate the commissioner's comments because I think they capture very well sort of my own thoughts on the new proceeding, which is I'm not surprised, but I am disappointed by the commission's decision. It seems to me that they're really stuck in sort of a 2015 mindset. And we can quibble about whether net neutrality rules made sense even then. But I think our experience from the RIF order forward, right, undermines both the legal and the policy rationales for net neutrality. On a legal side, which I think is probably the primary contribution I can make to this panel, right? Since the Brand X decision, courts have mostly been following the Supreme Court's guidance that it's kind of up to the agency to decide, will broadband be Title I or Title II? It's why we kind of get this constant back and forth between administrations. But that legal regime, right, that Chevron deference regime is under a lot of stress. I think it's much less steady ground than it was back in 2005 when Brand X was decided. As Commissioner Carr noted, the major questions doctrine has become a thing now, right? That courts should not assume Congress has granted agencies authority on questions of major political or economic significance. I've been arguing for several years that it seems to me like what is the status of America's major 21st century communications network is a question of both political and economic significance. The political significance can't really be disputed, I don't think, given the number of comments that activists keep priming the pump for every time this comes up for debate. But economic significance, the amount of money that changes hands as a result of what regulatory classification the internet's going to be. Both of these, I think, fall under the doctrine as it's evolving quite easily. And I was glad to see that others are starting to agree on this, including Obama's Solicitor General Don Verrilli. More generally, the Supreme Court is being asked this fall in a case called Loper Bright to really reconsider the broader question of whether courts should ever defer to agencies in a way that Brand X suggested. I don't expect this court will overturn Chevron, but I do think the outcome of Loper Bright is going to continue to perpetuate Chevron's death by 1,000 paper cuts. And I think it decreases the likelihood that courts could, or frankly should, defer as much as they once did to agencies. And that's the basis of the Brand X decision. On the policy side, net neutrality, I think, has always been a solution in search of a problem. And our developments in the law since the RIF order only reiterate how silly it would be to go back on that decision, right? So as Commissioner Carr noted, the primary driver of net neutrality policy is this idea of avoiding vertical foreclosure, right? Broadband providers are going to use control of their networks in ways that impact upstream markets. That's an FTC issue. This FTC has not been shy about bringing cases, especially against big tech and especially in vertical agreement scenarios. And the irony of Title II classification is that it strips the FTC of jurisdiction. It's the FCC saying, I know you're handling these cases everywhere else in the economy, but we got this one. For some reason, this is different. And I don't really see why. On top of that, as Commissioner Carr had suggested, right, the relative performance of American networks compared to European networks during a once in a century pandemic, when we all shifted our lives online, I think really reinforced the value of the light touch regulatory framework that we've gone with. The framework that prompted the investment that gave us the necessary bandwidth that we needed to get through that crisis. If there was any time when broadband providers had an incentive to block or throttle and make a quick buck off controlling a vital choke point of the internet, it was then. And we saw absolutely no instances of non-net neutral behavior. And of course, innovation since then, right? Things like 5G network slicing, innovation that the light touch framework allows and that are now called into question by the net neutrality rules, I think really cast a lot of doubt on whether it makes sense now to go back to this old regime, even if it had made sense way back in 2015, which I doubt. And finally, I think as Commissioner Carr said, that the bigger concern is net neutrality being a stalking horse for more comprehensive internet regulation. I'm sure we'll talk about that in panel discussion. I think that's a much greater concern now than it was even in 2015, given where the left is on these issues and the rise of a strong academic movement in favor of greater utility regulation nationwide.
Thank you very much, Daniel. Appreciate your thoughts on that. Rosalind, let me turn to you. What are your thoughts?
Well, first, I want to say thank you to Mark and to AEI for gathering today's session so quickly. I know that this announcement came out and everyone's been scrambling about what they have to say and reading 129 pages in a proposed item. And I want to thank, of course, Commissioner Carr, who always has intelligent things to offer, and really going back to his background as the general counsel at the FCC. He's seen so much go through. So thank you all. Great to be with you. And I know the AEI audience so well. Thanks for showing up today. And it's a very intelligent audience. And I think that for most AEI group, they really understand that, I think to that point, as Daniel and Commissioner Carr said, this is in a large respect control about the internet. Net neutrality, in a sense, is government regulation of the internet. And you can get it in the sense that if you build a network and then the government tells you how to price it, how do you manage it, how you're going to offer it, how do you market it, what you're allowed to do and not, then it's no longer your network. And that is a government control of your property. It's a violation of your property rights. That's a Fifth Amendment takings issue, and you need to be compensated for it. That's eminent domain. Daniel's written about this. So, AEI audience understands property rights and what that means. And what I want to share, however, is for those in the audience, maybe if you're a net neutrality supporter or you're not, you're not moved by the property rights arguments as many people are, why should you be concerned about this? And I want to give you 3 reasons. And so the first one I think that we can all agree about is competition. And when we look at competition today compared to 2015, we have more global competition than ever. And I think the key point we can all take away is that no 5G leading country in the world has hard net neutrality rules at all. We can look at South Korea, Japan, China, USA. None of them have had hard net neutrality rules with 5G at all. And it's very simple, because net neutrality is about a stupid network, basic transit for everything. It's all the same, a dumb core and smart endpoints. 5G is about intelligence. It's about the network being smart, using resources wisely, conserving certain resources, being able to give different kinds of services, the quality they need. So it's the complete opposite. And we can see for that reason, particularly Europe, which is totally floundered on 5G. And it's a true crisis for innovators. So that's one issue. I think the next issue is just the experience. you know, as Commissioner said, I'm a European citizen. I live in Copenhagen. I got my PhD studying this issue across 50 countries. In Europe, we've had this almost now 10 years. We have nothing to show for it. When this all began, there were 5 European top internet companies in the top 20 in the world. There are 0 today. This was all about creating innovation for European enterprises. The innovation has disappeared in the European content as far as internet goes. And it's quite telling because the UK, when it's left the European Union, the first thing on its list was to modernize their rules. The Ofcom, which is the European regulator, they came out and said, this is not good for consumers. Consumers are not allowed to buy the services that they want. And this is not good for innovation for our networks because we can't access the networks that we need. So and if you look at the market value of the European internet today, it's less than 2% of the world's total. Okay. Later this year, Europe will be surpassed by Africa in the market value of its internet, and European internet continues to shrink. So it has not done what it has promised for Europe. I would also suggest then, if you look at from the policy perspective, what kind of instrument do you want to use? Because as the commissioner was said, there are different ways that you can make rules. You can do legislation. That's the democratic way of doing it. Then you would not need to use Title II because the American people have consistently said, we don't want Title II for net neutrality. In fact, even ISPs have said, we're willing to uphold Title II, to uphold net neutrality if you make a proper law that defines the topic and what it's about. But that hasn't gone anywhere in Congress because American people are not interested in government regulation of the internet. There is interest in some kind of set of common standards across the ecosystem, but not slicing and dicing little bits of services we don't want and so forth. So that hasn't happened. Where I have seen success in my research in countries that use soft rules like guidelines, where there are multi-stakeholder models, you know, the way we have managed the internet since it was in inception. Different sorts of codes of conduct. Those existed in many European countries for decades before this took place. And then competition regimes. You can look at Australia and New Zealand, have never had rules at all. They are tremendous gaming innovators today. We don't see this blocking and throttling madness that the FCC described would happen without rules. So you can use different kinds of instruments, and but not a Title II instrument, because that itself is so ill fit. That the FCC would have to forbear from hundreds of provisions to get what they want. If you want to do it the democratic way, you need to make a proper law that says, what is net neutrality? Define it. And besides, no law's ever tried to do that. And then you say the provisions that you want to do. So basically, we've talked about competition, we've talked about innovation, and we've talked about policy instruments. And none of that has anything to do with what this FCC has said today. And I really hope that they will reconsider, but I hope our audience can learn something from this experience.
All right. Thank you very much, Roslyn. I appreciate all of that. So let me now turn to Jeff, and then we'll start taking some questions from the audience. And what you're saying is all raising questions for me as well. So Jeff, take it away, please.
Well, thank you, Mark, and thanks to all of my fellow panelists. I think we should all be congratulated for having the persistence or something to come back and be talking about this issue again after all these years. And thanks especially to Brendan, who is in the trenches and is doing a great job, kind of reminding people of the truth of the matter here. From an economic perspective, the central truth of the matter with respect to net neutrality is that the problem that net neutrality originally set out to address doesn't exist. And the problem in economic terms was posited that the content services offered by ISPs would be substitutes for, and therefore competitors with, the content services offered by over-the-top services. And initially, the thesis was that one of the first big net neutrality events involved BitTorrent. So leaving aside the fact that BitTorrent was a piracy service, the notion was that Comcast, which took steps to limit the amount of bandwidth that BitTorrent was using so that other people could actually browse the internet, download web pages. The notion at the time was that BitTorrent was competing with Comcast's video service, and that Comcast had this anti-competitive incentive and ability to discriminate against BitTorrent. That was unserious at the time in terms of the particulars, but the underlying thesis wasn't unserious as a theoretical matter, right? So entirely possible that when Netflix comes along, so it was unserious because BitTorrent was in no way plausibly, a threat to Comcast's MVPD services, right? So the notion that Comcast would engage in throttling because it was worried that BitTorrent was about to blow up its cable business was silly as an empirical matter, but as a theoretical matter, all right, worth thinking about. And a lot of work was done, in the original late 2000s, looking at that question in detail. A lot of economists, I was part of a group of 37 economists, 20, anyway, many economists, including Fred Kahn and some others who filed comments at the FCC, explaining why we didn't think that was likely. But now we've run the experiment, right? And what is now, we've run the experiment over the course of 20 years, and we've run it with and without net neutrality regulations. And what's now very apparent is that content and carriage are complements. That as many of us posited, Verizon's more than happy to have Google around because people buy Verizon so they can use Google. It's more than happy to have Netflix around because people buy Verizon so they can watch movies. And we now see partnerships and integration. And so the rather than the carriers and the content providers going at each other in an anti-competitive and in an anti-competitive way, they're partners in creating value. So that basic fundamental economic thesis underlying net neutrality at the time, which again I think was worthy of examination, it turns out not to exist. So the second thesis behind net neutrality was this political thesis, which is that big companies are conservative, or I guess actually big telephone and cable companies are conservative, and we need to worry about them discriminating politically against liberal causes, and I guess companies like Silicon Valley companies who were presumptively more liberally inclined. And so we had to be concerned about this discrimination on political grounds. Well, that's also turned out to be a non-issue, as anybody who I think knew very much about companies involved would have predicted. So now we go through this process of putting in place rules, in a tortuous way, with Tom Wheeler having his arm practically broken by the White House and forcing him to go down a path I don't think he was inclined to go down, Title II, really as a way of satisfying a political agenda. Ajit comes along and says, no, substantively the case for this isn't here. It's got the potential to do a lot more harm than good. We're going to repeal it. We repeal it. We saw what happened with that again. It's a political issue. And now we have the current chairman coming back. There's no way to explain. I read her speech. I've read parts of the order, and there's no way to explain, as Commissioner Carr has made clear in all of the materials he's put out on this. There's no way to explain this as a substantive endeavor. The only way to explain it is as a political endeavor. And that brings me to kind of the second point that I want to make, and I want to throw this to Brendan. It seems to me that we've come to a place with respect to the independent agencies where the underlying premise, which is that we would create these agencies to wrestle with the technocratic details of implementing public policy in markets with fairly reasonably well understood types of market failure. Initially, how do we go about setting the rate for shipping a ton of corn from someplace in Kansas to Chicago. And that was a question the legislature, the Congress said, we're just not set up to deal with. And we think we need some dispassionate experts. We're going to create these independent commissions and ask them to deal with technocratic questions like that. And in order to do that, we think it'd be useful to combine these three powers of government, the legislative, the judicial, and the regulatory, and the executive, together in one agency. And the Supreme Court at the time decided that was an okay thing to do. And you could make an argument for that, right? So the progressive ideal of government through the scientific method, again, isn't an inherently bad idea. And maybe at times it's been a reasonably good way, or the least bad way, of dealing with public utilities, which are natural monopolies. But what we see today from independent agencies is just rampant politicization. The pursuit of political agendas for political purposes, for the accumulation of political power. We see that at the Federal Trade Commission today. We see it at the Securities and Exchange Commission today, which decides that its job is to deal with the climate crisis. And we see it here at the Federal Communications Commission, which is now embarked upon this intensely unserious enterprise. And unserious in the sense, coming back to my first point, and then I'll stop, that the underlying problem which these rules were designed to address manifestly doesn't exist. And all of these kind of excuses, from national security to outage reports, are vacuous, are foolish, or don't withstand even the slightest scrutiny. So what you have here is a political enterprise embarked on a political mission for a political purpose to satisfy a political constituency. That wasn't the idea. And I think it's time that we think about letting all these things sunset and solving the legitimate problems that are here. There are technocratic problems, finding another way to get this problem solved. Enough said.
All right. Well, thank you, Jeff. And Commissioner Carr, Jeff was leaving you with the question. I would like for you to answer that. Plus, I want to add to it a comment from our audience. So Jeff was saying that this challenges the institutional structure, the integrity of the ideas of having independent agencies. We have a question from our audience that kind of fits in a little bit with that says it's unfair to frame this as a left versus right, Democrats versus Republican issue, because there are a lot of Democrats that don't agree with the path the FCC chair would like to go down. And since you spent no small amount of time with a 2-2 tie at the commission, and everything you did had to be bipartisan, you're in a unique position to talk about that as well. So share with us your thoughts on those issues, please.
Well, look, I think you're right. I think there's plenty of voices on the left that sort of understand the difference between net neutrality and Title II and have a history of speaking out against Title II. In fact, if my memory serves me, and at this age it oftentimes doesn't, the Washington Post editorial board came out and said, I think the last time around, there's got to be a better path forward than Title II. And I don't know that Washington Post editorial board is traditionally associated with the right. So I do think that that's right. To Eisenach's point, I think, which is an interesting one, probably get me in trouble, but I'll speak to it anyways. I mean, there's an element of political pressure outside of the FCC that goes back almost to our founding, right? But it usually arises in the context of, I think, as he was saying, sort of hot button political issues, separate from the knitting work that you really sort of need an expert agency to do. And so as broadband has become more central to the lives of Americans, as it has become more central to the platforms of presidential candidates, I think you see a lot more talk about it, a lot more pressure on the agency. I think there's a couple of solutions to that. One is what we're seeing with the major questions doctrine and with some of the duck bites around Chevron, which is, to the extent that we can keep the FCC and other agencies clearly within the lane of what's delegated on sort of like to experts on certain things, the better. And so I think one salve, got that word right? One way to mitigate pressure historically on the agency is EPA versus West Virginia. Ultimately carried to its conclusion, at least logically speaking, you could see a world in which the FCC should be doing more, sort of almost like committee work, advising and coming up with drafts that then themselves could be taken to Congress and codified. You could also see as another solution sort of more robustness to Congressional Review Act, FCC decisions that require, more clearly votes in Congress. So I think there's ways that you can go make sure that what we do truly is sort of the expert knitting that's expected, and leave the big political questions for America's elected representatives. I mean, look, it's a two-way street. You can look at Congress and say, well, they're not, really that productive these days. And trust me, I'm very well, I won't go that fast, but I'm very understanding of the fact that there's some challenges in Congress these days. So, to say, well, the legislature can't act, so the agency has it backwards, right? The more that we sort of don't go out of our lane, the more likely, maybe it's a long time, right? Maybe it's not overnight, we'll get back to the place of the legislature actually legislating. So I guess long way of saying the political pressure isn't necessarily new. You see it exposed in hot button issues that become, nationwide, and there are solutions. EPA is one, looking to Congress more, or others.
All right. So
Daniel, do you get something on that?
I'm sorry. Yeah. So Daniel, jump in on this, please. And I also have while you're speaking, if you could also elaborate a little bit on this Chevron versus the major questions doctrine, because there's something perhaps here that we're also seeing over the Federal Trade Commission, and that is the willingness to take on an issue that the agency might actually lose on, and that being seen as a positive thing. Elaborate on these, please, if you could.
Yeah, so one thing I wanted to build on the commissioner's comments is that it's not a sort of hypothetical or a pipe dream that might be a political solution to this. We were almost there, right? In 2014, on the eve of the Title II order, there was a proposal in Congress that had bipartisan support that would have adopted a middle ground. It was would have legislated by statute and no blocking, no throttling, no paid prioritization rule in exchange for agreeing not to impose the rest of Title II onto the broadband architecture. It was there, and it got cut off largely by the agency moving forward with the Title II proposal instead of allowing the political process to go forward. That's, I think, an important piece of the history here that has been memory hold. It holds out that you could have had a compromise bipartisan approach that would have stopped all of this back and forth. And could that the agency's insistence on moving forward undercut, and ultimately to what end? To have a 2-year arrangement, then got the rug pulled out from under it. On the broader question, what happens if the agency goes forward on this and loses? Right, what it means is if the agency doesn't get deference on what Title II means, whether Title II applies. It means the court's itself going to decide where broadband best fits in the 1996 Telecommunications Act. And I will say the act is kind of a mess, right? And it's a mess for a reason, because it was written in a completely different context. It was written at a time when only 50% of us had internet access. Most who did had it via dial-up, right? That service made that weird like donkey static noise, right? And it was designed primarily to jumpstart competition among local telephone providers, which is a category of businesses that has not existed in the United States for a decade and a half. So how is a court going to decide this? I'm not entirely sure. I think it's the better of the arguments is that Title II was really meant for a telephone network, and you can see that by the number of things that the agency proposes to waive in Title II that just doesn't make sense to apply to a broadband network. But a judge could have gone the other way. And so one of the concerns of teeing this up again, rather than trusting a political dispute, is you've just changed the identity of the unelected decision maker that's going to decide broadband regulation, moving it from the agency to a court, when in fact this really is something that Congress should address with a statute that makes sense in the modern era, rather than trying to figure out how an old 1996, I was in high school in 1996, how a 1996 statute should apply to 21st century networks.
All right, thank you. So Rosalind, I think you have some thoughts on the political context here and what's moving what.
Well, I mean, it to me, it's so telling, that it was, I think it was the third commissioner to the FCC, barely was her seat warm. And then this thing drops, the political context was so real. And, so much of this was, this can't be, because there's not general support in the electorate to do this kind of method, to do this sort of regulation, that it can only be done in an agency where there's a majority of one party or the other. So that itself is telling. But the bigger part about this, it's interesting to step back and think about, well, what's going on? Like, who's driving this? Who's really, what political constituency is benefiting? I did a paper for AEI in 2018 called Tech Policy and the Midterms. And that was looking at what is a sort of symbolic politics or a political theater that goes on with this, because it's not just that the FCC, really the FCC doing the rules is not so interesting. It's all of the fanfare and the opening this big public comment and crashing the server with millions of comments and the late night comedy and all of this kind of thing that creates this sort of theater. And that serves a political purpose. It really has nothing to do with delivering networks that we want in America, but it does this sort of teeing it up for the 2024 election and saying, oh, the president has delivered on this promise, is a great way to distract from other things that haven't happened. I would just like to submit, though, it was so interesting if we look at the European context where we've had rules in place and how much they have killed any kind of innovation, mostly for small innovators, talking about small ISPs and small content providers, where it's so damaging. For example, there is a whole set of network slicing rules, which no ISP even dares to touch. They don't try to do anything because everyone's afraid they'll be sued. But what happened when the Ofcom said, look, we want to modernize this, it's not working, Facebook and Meta get up and say, oh, no, we need to have net neutrality rules in UK to innovate. I mean, it was totally ridiculous. It was a pure way that basically was for Meta to say, we don't want to pay for the quality that we need for the metaverse or for AVR, VR. We want to have consumers pay that cost, or ISPs eat that, because we don't want to pay what the law says we should. That provision was made. So what I want to give some progressive antitrust scholars some credit here, because they've realized these rules have been used by big tech to protect their competitive advantage, to deter new innovators into the space who could be using the capabilities of 5G to get the service quality that they need, to get the delivery quality that they need. They can't build the CDN that Netflix can, that whole system, put their server deep into the network, but they could buy some kind of a service package to do so. So it's been most hurtful for small ISPs and most hurtful for small content providers and consumers in general who want to have premium services. They're not allowed to under these rules. They have to pay equally for ad data than the data that they actually want. So I actually think that if this does go forward, it will end up at the Supreme Court as a free speech issue, because consumers are being compelled to value all data the same when they fundamentally don't.
So Rosalind raised an important issue, at least I believe it's important. And that is that if you look at the large tech companies, they pretty much don't use what we consider the public internet. They have private internets that are customized to their particular needs. So what net neutrality does is not so much touch how they use the internet broadly defined, but how their small rivals might be able to use it. And I was just wondering if any of you would like to elaborate on that, this nature of the public internet versus private internet, and what kinds of companies out on the edge are affected by any kinds of regulation of the public internet. If you don't, that's fine. I just thought I'd raise the question.
Well, I will just give you an example. I work a lot with the safety community, child protection community, and there's a real desire amongst consumers that would want to have a curated internet where they said, look, I don't want to have adult sites. I don't want to have harmful things. I want to protect my child. Please block these sort of things. I'd like to pay for that kind of service. So interestingly, if we look at the corporate ISP market, they're able to design a bespoke network exactly as they want. They say, look, I'm only going to 2 destinations. Please provision my service exactly for that. I don't want this extra things. And so if we look at private networks for industrial manufacturing or whatever, that's exactly the business case or the use case. It turns out consumers have various reasons to want exactly the similar thing. And what I would say is we have a net neutrality hangover in America, which even though the rules aren't there, there is still a kind of expectation that, well, we're not going to try too much because the zombies are going to come out and start claiming that we're doing non-neutral things. So this people who've been hurt here are actually real consumers who are not able to enjoy the kind of capabilities that companies can. And I think I agree with you. It's absolutely the case that, there's parallel internets all over the world today by every major tech company. They have their own undersea cables, their own content delivery networks, their own server farms, data centers, you name it. Of course, not to the middle mile or last mile, but they're maintaining for their specific data, and they're prioritizing and managing it to their standards. It's not a neutral standard, it's for their proprietary standards. Those networks are not open to their competitors. They built it, it's their property, they're doing it to give a good service to their customers. So if we applied the net neutrality standards equally to all of the ecosystem, everybody would get a failing grade. The ISPs are the only ones who are upholding the rules, and everybody else is violating them. So I think this is part of the reason these advocates for this have not gone to Congress, because if you actually have the real discussion, everyone will say, well, gee, doesn't Google have to be neutral? And why is you're throwing me off of Twitter and not explaining, or how come he's shadow banned or whatever? All of those standards will fall apart if they're applied equally.
And to build on that, so Rosalind focused on the consumer angle, and I think she's exactly right about that. But this administration seems to be more interested in small businesses than in consumers, at least as far as competition policy goes. To the extent that's the right framework, and I don't think it is. Net neutrality, you can build an argument that net neutrality really harms smaller providers specifically of latency dependent applications, right? If you are someone who for whom network congestion is a problem, right? There's only really two ways around it. You either pay for priority along ISPs to get to your consumer, or you build your own private lanes where you can prioritize your own content because you're not an ISP. Wealthy, well-resourced companies can afford to build their own CDNs and bypass the public internet. That's what Netflix has done. If I am starting my own video content provider and I can't afford that massive outlay, net neutrality is cutting off the only other option I have to level the playing field with Netflix. So it's actually, in a way, entrenching existing power players, at least with regard to latency dependent applications.
Right.
And if I can
Go
jump
ahead,
in
Jeff.
here for a sec, and I'll be brief, but I think I disagree a little bit with some of the other panelists on the notion that we ought to find a less destructive way than Title II to do the wrong thing. Why is it the wrong thing? So in general, government intervention, ought to be considered when there are market failures, when there's at least a plausible case that government intervention can make the world a better place by addressing some kind of externality or public goods problem or market power problem. None of those things exist here in any plausible way. So finding some better way to put in place a set of rules than Title II, it may be better, but it won't be harmless. And the reason it won't be harmless goes to the fact that every expansion of government power creates a market for the use of that power. This is Stigler's point, Posner's point, Tollison's point. It's a rent-seeking market. So every time the government puts in place a vehicle through which powerful interest groups can shift wealth from other people to themselves, they're going to use that. They're going to maximize profits. They're going to spend resources to get that done. And at its heart, that's what half the net neutrality debate was always about. It was always about the content providers, the OTT providers, the Googles and the Facebooks and so forth, trying to impose price controls on ISPs that would establish that the pie of value that they were creating together would be that they would benefit disproportionately from that, as opposed to sharing in proportion to their value added. But any form of rules in this context going forward is going to create more opportunities for doing that, and that's great. At the end of the day, it's not obvious that that's great for anybody in the private sector, because they tend to fight to a draw and spend lots of money to know, ultimately there are no winners. At the end of the day, the only winners are the government agencies, who are and others involved in the public policy process, like all of us, who get paid to engage in these things. But the public net is a loser. It's dead weight loss in all caps.
So Jeff, in a moment, I'm going to turn to the commissioner first and ask him how this affects, one way or the other, the FCC's work over the next couple of years, I guess is fair. But I'll come back to you, Jeff, just asking you to describe, with Title II, without Title II, what does our online ecosystem actually look like? What changes either direction? And for the kind of majority of voters out there, what's their skin in the game? So, Commissioner, just thinking about if the FCC goes down the path of at least the investigation and maybe the adoption of Title II regulations for broadband, how does that change what you're able to accomplish as a commissioner over the next, let's say, 2 to 4 years?
Well, look, I sort of indicate, I think going down this path, in fact, this is actually what Solicitor General Verrilli and Gershenborn said, is that it's going to take up a tremendous amount of oxygen at the FCC, and it's going to move so many things to the back burner or beyond. I mean, we are behind schedule at this point when it comes to spectrum. So we've lost our spectrum authority. We at the FCC are not articulating a clear vision about spectrum bands that we would move if we had authority. And I think if we'd been doing that, maybe that would have made it less likely that we would have lost our authority. I've put out my view of where I think we need to go from a spectrum authority, from a spectrum band pipeline perspective. I think the whole agency needs to do that, but that's less likely to happen now. There's infrastructure reforms we still need to do to help make sure that, BEAD, its money has already been allocated, is spent as efficiently as possible. That's going to be less likely to happen. And fundamentally reforming universal service. I mean, there's a lot of questions about contribution, about distribution, about how it pairs with a lot of else going on. Sort of the time needed to ask and answer those fundamental questions is going to be either eliminated or constrained upon. And so there's a lot of things that is necessarily going to have to go to the back burner for Title II, and ultimately for no good reason, both because we'll be overturned by the courts and because we have a free and open internet today. I mean, again, when we went down the path of eliminating Title II regulation in 2017, we put a transparency rule in place, and all filed with the FCC. Are you going to block? Yes or no? Are you going to throttle? Yes or no? Are you going to engage in paid prioritization? Yes or no? They've all made those filings. They've all said no. At least the ones that I've seen. So today, if like AT&T or Comcast blocks a website or throttles something, that is a violation of the transparency rule, and it is enforceable by the Federal Trade Commission as an unfair or unjust business practice. So the very same rules that we're going to do all this collateral damage through Title II with, we have that same outcome today. And in fact, again, if you read the DC Circuit's decision, I mean, I know it's sort of a mind twister for a lot of people, but we have stronger, more enforceable protections today than we would under Title II, because again, DC Circuit said you can just disclose your way out of the Title II regime.
All right. Thank you very much, Commissioner. Jeff, back to the question I was posing to you. If the FCC votes next week to go down the Title II path or decides to not, what difference is that going to make for most voters?
I think none at all. I think it makes again, I think we've run, let me put it a little differently. It's a subtle difference over time. So I think we see the impact of the corrosive impact of the corrosive impact of the growth of government power in this sector in Europe. So I think what you see is you're on the slow path to becoming Europe, but that's the classic case of boiling the frog slowly. There's no cataclysmic moment at which everybody says, "Oh my God, the internet as we know it has ended." Unlike those who claim the internet as we know it will end the day Ajit repealed and then the commission repealed the rules in 2017, no, we won't see that. But what we will see is the increased empowerment of interest groups and the increased empowerment of the Federal Communications Commission, and I think unpredictable forms of interference in the marketplace because while lobbyists and lawyers, are not necessarily creating value. That doesn't mean they're not entrepreneurial in the ways they go about finding ways to shift value, to use the power of the state to shift value. So I think it's hard to predict exactly what forms that rent seeking will take, but what we'll see is an increase in rent seeking. And I know we're coming up on our time here, so I would just like to close by saying that, for my part, saying that I would support Commissioner Carr as the first administrator for communications policy over a new agency with a single administrator, as opposed to a politically appointed panel of administrators, of commissioners, and would love to see that happen in my lifetime.
I didn't see him jump for joy with that proposal, Jeff, but
I think he's being throttled, because I don't see.
So, audience, we have 15 minutes left. If you have questions, please put those in an email to Kate or on Twitter or X, and we'll get those picked up. Rosalind, let me turn to you for something. There's this curious position, provision in the proposed notice of proposed rulemaking about general conduct standards, and they seem to be a little vague. Could you talk with us about those? What's that really about? And if it's adopted, what happens? Oh, you're muted still, like I was earlier.
I was following Kate's instructions. So, so no, I think I was describing exactly what Jeff was talking about. There is what's so galling about this proposal of rules: no blocking, no throttling, prioritization. AEI will lawyer, Dan and everyone will unpack all of those and how they're difficult legally and how to stand those. Then they put in a general conduct standard, says, well, we can do whatever we want. And what happened, you want to talk about predictions, what happened towards the end of the Wheeler FCC was all the free offers were going away, were being challenged. So a key issue would be like the VA Connect. 3 million veterans have been using their mobile phones for healthcare beginning in COVID, where they can use their mobile phone. It doesn't go against their data package. And that allows them, this meant a lot in COVID because hospitals were full, maybe they couldn't travel, but they could see their healthcare provider from their phone, from their home, or wherever they may be. That is the kind of thing that will definitely go away. That is something that millions of veterans use today. Say goodbye to that now, because California rules don't want that, and that is going to become the national standard. And unfortunately, there's a negative, in my view, that what's driving that is a sort of certain big tech entities that want everybody to have fiber to the home networks and not mobile wireless networks, which they might prefer, or whatever the case may be. That is the way to put the thumb on the scale in favor of one technology or the other. But what was happening at the end of the Wheeler FCC was the killing of all sorts of free offers. The consumers loved, and I think, credit to Chairman Pai and Commissioner Carr and O'Reilly. The first thing they did when they got new FCC was saying, we're not going to enforce that general conduct standard, because that was used to take things that consumers love and get rid of them. And so, that is, again, coming back to unintended consequences. I have one quick point that I want to share that, being my area of this issue was, if you look at what the apps we use today versus back in 2015, they're Chinese apps. The only country that has actually been using apps, presenting apps to Americans, it's not coming from Brazil or India or Europe, the places with these rules, or Latin America for that matter. It's coming from China. And our open internet gives them a free ride, a free road to you. Americans can choose. But it's interesting, for the billions of people in the rest of the world under net neutrality today, those innovators are not creating the innovation that we use. It's coming from China. So it's a country with no net neutrality rules, maybe no rule of law that we would recognize. But that, I think, is very telling if the whole innovation argument has been buried in this order. It used to be the main thing. FCC now does not discuss that, because I think it's become an inconvenient truth, because it is not promoting the open innovation that we want.
All right, and Rosalind, I'll come back to you in a little bit. a little bit more on the European experience, and maybe I'm wrong, and you can correct me. But one of the things that I found curious is when Europe said that, gee, we really don't want these broadband providers charging the content providers, big tech companies, for the more use of the internet or for features on the internet. But then then they ran into trouble financing broadband with their excessive regulations. And so now the government is going to tax people to do that. I just want to know if that scenario is correct. But let me go to Daniel next. So Daniel, we've talked about what we framed the legal challenges for the FCC in terms of Chevron versus major questions doctrines. What else might be the legal challenges, or are there none? This is pretty much frames the difficulties or the hoops the FCC would have to jump through.
So there'll be two different sets of challenges. One we can predict with some certainty, which is, does the FCC have the power to do this? That's the Chevron question. The other, which remains to be seen, is how the agency goes about doing it, right? Sort of Administrative Procedure Act challenges to whether the agency read and reviewed the comments, whether it provided a reasonable explanation for why it's going the way it's going. We call that an arbitrary and capricious standard. Much of that review will depend on what the final order looks like, and we won't know until the commission acts in the spring. But I bet there's a whole lot of lawyers now who are already trying to figure out how to justify the imposition of net neutrality rules against a backdrop of absolutely no facts suggesting that there's a problem to be solved, right? It's a little bit of an uphill battle. It's not one the agency can't overcome, but it is one the agency is going to have to fight hard in order to sort of hit all of its procedural marks. And that's a place where I anticipate opponents of the coming Title II reimposition order to also focus some of their firepower.
Okay. So Ross, I'm going to go to you next. Jeff, I'm going to come back to you. You've been a person who's advocated that, you know, Congress needs to fix, you know, what we should be doing here one way or another. I'd like for you to elaborate on that a little bit. But before we do that, Rosalind, tell us about Europe's experience by saying we're going to make broadband less profitable, and oops, now we have problems. Tell us the story, please.
Well, if I could summarize European telecom regulation, it would be the definition of insanity. You know, doing the same thing and expecting the different result. I mean, about a week ago, the European Commission issued a report saying that Europe lacks about $200 billion in network investment to achieve its goals for 5G and fiber to the home. That's like saying American broadband providers sit on the sidelines for 2 years, do nothing. And that would be Europe. Because what America would do, what the amount of investment we have in the United States, it's on the order of $90 billion a year. It's a quarter of the world's total. It's a staggering amount. And it hasn't, even as the pie of the world investment gets larger, you know, with China coming in, the American broadband providers keep stepping up in terms of the investment they make. So, you know, credit to them. But at the same time, the European telecom companies are shrinking. They are doing less. When European Commission says we need more, or we want AI and we want 5G and we want, you know, intelligence and this, that, and the other, and the market itself is growing maybe 1%, but less than that, barely moving. So there's no revenue to fund investments. There's a refusal of the European Commission to look at consolidation, also to look at spectrum. Imagine trying to use 30, 40 markets to buy your spectrum. You don't have one country, one continent. You have to go to every single market. And then when you buy the spectrum, the license has a life of 20 years. Okay, you cannot build a business with that. And investors don't want to be part of that. So, you know, interestingly enough, Deutsche Telekom, they get their profits from T-Mobile USA. You know, that's where they put, you know, that is their revenue driver. It's certainly not in Europe. It's very unfortunate because Europe has a lot to offer the world, has many intelligent people, but this is a terrible insanity of the state of European telecom regulation, which unfortunately, Thierry Breton, who himself was the head of France Telecom, if I'm not mistaken, who's not willing to take the leadership to change it. And we continue, they've said the same thing for 15, 20 years at least. And we've done papers at AEI all about this. I think some people in the US like it because the investment goes to you American broadband providers, But sadly, I actually think with an $8-9 trillion market, there's enough investment for every region of the world to get the networks that they need. But unfortunately, regulation is driving it out of the places that it needs, very sadly.
I remember seeing a report just a couple of months ago that the entrepreneurial people in Europe that come up with really good tech ideas move to the US, which we're glad to have them. We want aggressive, innovative, hardworking people developing businesses. Glad to have them, but it's really sad they have to leave their homes to do that. So, Jeff, let me turn to you, because one of the things that we've talked about over several months, the struggling of the agencies, which you talked about. If you could, I guess, wave a wand and have Congress do what it should do to make this system work the way it should, what would you do? What would you have Congress do?
Well, I think I do think that this proceeding, and ultimately, I really do think it's unserious. I think, I don't think we're going to see people demonstrating outside the FCC because I don't think the political energy is there for that. I don't think we're going to see the tech companies investing tens or hundreds of millions of dollars in a lobbying effort because I think they've got other things on problems to deal with and realize that this is not a serious problem. So I think this will turn out to be as empty an exercise as it is substantively. I think it'll turn out ultimately to be equally empty from a political perspective. At least maybe that's a wishful thinking, but I think it's possible. But I think what it does do is it does really raise the question of whether it's time to rethink this notion of independent commissions as a means of dealing with difficult technocratic problems. So the world's not getting to be a less complicated place. It's getting to be more complicated, and having the rule of law in a complicated world requires the making of complicated. Everything can't be simple. You do need to make rules that acknowledge and understand and deal with the complexity of the economy and the underlying institutions. So fair enough. But we have two ways that we're doing that in the US today. And one is through these independent regulatory commissions. And the other is through single administrator regulatory agencies. NHTSA comes to mind. And I really do think it is time to take a look at whether the independent agency model, whatever its merits may have been or not over the last 100 years, whether it's come a cropper for a lot of reasons that probably not to go into today, but one would be the political polarization, which has led to too few Brendan Carrs being appointed to independent agencies and too many strongly ideological advocates who are there to serve a more political purpose. I think in what may be a coming time of fiscal discipline, unwanted by the politicians for sure, but possibly forced on them by circumstances. Maybe there could be the will in Congress and in the executive branch to rethink the way we go about doing these, and rather than having what are now these kind of independent political entities running around pursuing political causes, to find a more efficient and effective way of addressing what are the underlying substantive problems.
All right, well, thank you, Jeff. And we're about to the end of our time. So I'm going to ask each of you, just in one sentence, what would you like for our audience to take away from this? I'll begin with Daniel, then we'll go to Rosalind, and Jeff, you'll get the final word, then I'll wrap up. So Daniel, one sentence, what should people take away?
This was always a problem, a solution in search of a problem, and even more so in the development since the RIF order came about.
All right, Rosalind. Oops, you're muted.
No leading 5G nation in the world takes the Title II approach. If we do, we will end our 5G leadership.
Very good. Jeff.
Now is the time to, this is a perfect example of why it's time to rethink the administrative state and find a more effective way to solving these problems that need to be solved.
All right. Well, I'd like to thank Commissioner Carr. He's already left us, but very grateful that he took the time that he did to be with us and share things with our audience. Daniel, Rosalind, Jeff, thank you very much. Your insights have been really excellent. The battle for internet freedom evidently never ends. So I'd like to thank everyone for being with us, our AEI staff for helping put all this together. To our audience, watch for more things coming from AEI. Share your thoughts. Let us know what you would like for our scholars to be looking at. Thank you very much.